Hi, everyone. Thank you for joining us for this conversation with a lawyer. As we start, this conversation is very close to me. A few weeks ago, a friend of mine, a very close friend of mine, called me and told me, Jennifer, I want you to help me with something because you work with children and all. And she told me, I want to do a will for my children. I said, my girl, you're 35 years old. Why do you want a will? Say, I have two little children. I have been working very hard for whole of my life, and I don't want something to happen to them or for them to struggle as because of if anything happens to me. Say, but what can happen to you? You exercise, you eat proper, there are those people who are very, very strict in whatever they do. And she told me, no, I just don't feel right. And it's a few weeks back. And that got me thinking, even myself, the only thing I tell my parents, if I die today, please don't bother buying a casket or having these big funerals. Take me to Kariako and we're done, cremation. That's the only thing that, like, for me, I tell my family. But it's something that, especially you have little children and you have done some investment, you need to start thinking. We start that conversation, this week's conversation from there. Enrica.
Yes, Jennifer, good morning. Good afternoon, sorry.
Oh, good afternoon.
It's afternoon. Yes, yeah. This social distancing, you even forget the day and sometimes the time.
Yeah.
Yes, now this is a conversation that I've had before. And it's planning for your children or planning for your affairs, whether you are here or after you've gone, it's a whole, I'd say the whole thing would be called family estate planning or management. And where you are a single parent, it's important that you plan for your children how you'd wish for their affairs to be managed in the unlikely event that you precede them in death and you leave them as minors. But there are instances where also both parents die simultaneously or one die shortly after the other and they leave young children. So I would encourage us that whether you are a single-headed household or whether both partners are in existence, you should be able to plan for your children with the thought in mind, how will my affairs or their life be managed when I'm not there? Some people give the argument, but I don't have assets, so why should I write a will? You may not have material assets, but you have children. Whom would you like to take care of them once you are gone? So that is the background of all this conversation. Now, in Kenya, we have, or not in Kenya, sorry, but under the law of succession, we have what is known as a dying intestate and a dying testate. Now, majority of us in Kenya die intestate. That is where you live and you die, and after your death is when people, your family mostly start asking, what wealth did he or she have? How do we transfer this? And to whom do we transfer it to? And that's when wrangles start coming in. And sometimes, unfortunately, your immediate dependents get disinherited, as is common. And sometimes you also have assets which you never disclosed. And so your family does not know where your property is scattered. The other one is where you die testate, where you left a will and your property that you had at the time of writing that will was included under it. And even where you've written a will and you acquire property later, it's important at the time of drafting the will that there is something known as omnibus clause that is included. Briefly, that any property that you shall have, the omnibus clause means that any property that you shall have acquired at the time of your death, that it shall be distributed as per the provisions of your will. Now, in family estate planning, you have about 3 things that you can do. One, and the most common one, is writing a will. Number 2 is you can create a trust. Number 3 is you need to have a power of attorney. So I'm gonna start with the will because this is the one that we know mainly of, that we speak a lot of in Kenya. First of all, if you wish to write a will, there are 2 types of wills. There's the written will and unwritten will. But the rule is very clear. If you have unwritten will, the one you verbally spoke out to your close associates or family, the rule is you should have died within 3 months of creating that verbal will. However, also verbal will are mainly restricted to certain categories of people. That's under the law of succession, it provides that. Then we have the written will. For you to make a valid written will, I would advise you don't just sit down on your own and write a will because there are rules. Example, someone who is to benefit under your will should not be a witness. And then you also need to elect someone who is going to be the testator of your will. So I would advise anyone who wishes to prepare a will, please seek the services of an advocate. They will sit down with you and they will help you create that will as per the provisions of the law. Now, under the will, you can also appoint who you'd wish to be the guardian of your children should you precede them in death and you leave them as minors. Even if you've not left them as minors, but assuming they are probably 20, they're still in college. Our law allows for enhancement of parental responsibility. So you should and you can, under a will, appoint guardians to your children. Under a will, you can also have something known as power of attorney. You can either have it independently or under a will. That should I be sick where I'm unable to manage this, this, and that? Should I have traveled, what? Who do I give the power to manage this? So my advice is, if you are interested in writing a will, please seek the services of a lawyer. Don't sit down and say, nitaandika tu mali yangu yote na nitaandika vile nataka it to be distributed when I die. Then in law, we have something called dependents. These are people who rely on you, whether it's 100% or not, even if it is a niece or a relative who is living under your roof and relies on you for their education, that person becomes your dependent. When you pass away, the law allows them to claim a share from your estate because they were your dependent. It does not mean that they will get the same share as your children or as your wives, but they have a right under the law. Now, something else that we need to be quite careful of, whether you are married under civil law or you are married in church and there's a marriage certificate, then in the event that your husband contracts another marriage, customary, the law does not recognize that marriage when he's alive. But when he dies, the law recognizes that woman. For purposes of succession, the law recognizes her. And she will inherit equally under his estate. Now, if your husband has children, or if you as a man, you have children, and currently you are not providing them with maintenance, probably maybe they are known or they are unknown, they are in existence, you've refused to provide them with maintenance, but when you die, the law recognizes them as your dependents. So under the law of succession, there's no distinction whether the children are born within marriage or outside marriage. Under the law of succession, it doesn't matter that I am the only wife, here is my marriage certificate. If another woman shows up and she has proof, the law will provide for her. Again, under succession, if your husband had another wife after he's married you, and this woman came with her children, and he was maintaining this woman by paying rent, and of course the children live with her, Unfortunately, those children become dependents to your husband. So they don't even have to be his biological children. Just the fact that he was maintaining them through their mother, they had acquired the status of his dependents. So we need to be very, very careful. To avoid wrangles, it's painful when during succession, when all these people come in, especially where there's a lot being contested, it's painful, but to avoid the case dragging, if it goes to court, to avoid the case dragging, you need to, if you're in such a situation, you need to consider sitting down and doing an out-of-court settlement. Now, the second one that I would like to talk about, again, still under the will, apart from appointing guardians, you can also make a decision under your will how you'd like to be interred. Jennifer, you've mentioned that should you pass away, you'd like your parents to have you cremated. It's important if you reduce that in writing, put it in writing. We are Africans, most of us are cultural. We believe a lot in being buried. We believe in huge ceremonies, which is okay. But also, our generation, we are a bit different from our parents' generation. Some people have very, very little connection with the ancestral lands. Or even if they have connection, they still feel it's a waste of resources. So if you wish to be cremated, please have that captured under your will. Even if you don't want to be cremated, it's still important that you write where you want to be buried. Assuming I'm from Mombasa, then I bought land and I've settled in Ruiru with my family. But remember, ancestral land is in Mombasa. When I die, where do I want to be buried? Do I want to be buried where I've bought land and settled in Ruiru, or I want to be buried back in Mombasa where I am from? So you need to reduce that in writing. And some families also, even during their lifetime, there's a tug of war in regard to faith. Probably you are both Christians, but different denominations. And during your lifetime, there's already a wrangle. Please, under your will, you can also and should state clearly that when I die, I'm a Roman Catholic. I want to be buried by Roman Catholics. And probably your spouse is a member of another church, but during your lifetime, each person used to go to their own church. And probably you have children, it's passionate to them that the mother or the father is buried as per the traditions of the church which they were member to during their lifetime. So please reduce that in writing. Some of these things we take for granted, but they can cause great family disunity, and you'll not be there to help them answer or to give them your last wishes. So it's very, very key. Consider writing a will, factor in all your dependents, get an advocate, sit down with them, and they'll help you write a proper will as per the law. Now I move to the second one, which is known as a trust.
Enrica, before you move to trust, so yes. You've mentioned about like who are the dependents,
yes.
So I've come with, as you said rightly, our generation is different from other generations in terms of we are very forward moving. Like, for example, yes. I would want to adopt a child, for example,
yes.
and they're not my biological children. And probably my partner is not does not want to have like an adopted child. So can I include that child as my own? So that child can be my child. Maybe I adopt a child and then I get married, for example, and then, yes. But that child is not, and then I get biological children later.
Yes.
It's happening. So what happens to that child yes. that I adopted? That child is not my biological child, but I want to leave something for them, and that is why we have seen issues of adopted children being disinherited by so many yes. people, and as you say that now we're in Corona and everything is social distancing. If I would want yes. to start doing this process of inheritance, writing a will, there are so many templates online. There are so many templates online right now. Am I able to go to online and get a template and type it out and say that this is my will?
Okay, the first one about you have an adopted child and then later on you get married. First of all, I think it will be very unfortunate that you have a child and then you later on get married, but your partner, your then husband, is not welcoming of this child. But as per the law, that child is yours. Huh? Whether they were adopted and then you later on have other children biological, remember adoption order is final. That child that you've adopted will inherit equally to your biological children. So regardless of the wishes of your partner, that child will inherit equally. Then number two, please remind me what's the question again? The second one?
So the other question is, how can we, for example,
do
this
will
process?
template,
yes,
yes.
This process, yes.
Yes, it is true that you can get a template online, but remember you are a lay person. You are not you're not landed in a law. You've not practiced, so you will not even know if what you are doing is correct, because you get a template. The templates online, most of them are done by students. I would still advise you that you get legal services, because everybody has read the law, but it's only advocates who know the interpretation. And besides reading the law of succession and getting the template online, what a lay person doesn't realize is that there are rules and procedures that accompany that law. But because you're not a lawyer and you're not a practitioner, you will not know that. So in as much as you can download a template, I would still advise, for that will not be challenged later or considered as not properly executed, get the services of an advocate to help you produce your will in writing as per the written law. Thank you. Yes, Jennifer?
No, go on to okay. Trust.
Okay, now we'll proceed to trust. Now, trusts are not very common in Kenya, and a lot of people don't know about them. People think that, oh, the only way I can secure my property is through a will. Remember, if you write a will, for that property to be distributed to your family, for like if it is land or houses, the only way it can be distributed and transfer of title made is when they go to court for probate. But if you do a trust, there's no probate. And if you do a will can be challenged. If you do a will and you do not adequately provide for your dependents, or you not include all your dependents, it can be challenged, and it will be challenged successfully, so long as these dependents come and show that we were his or her dependents and they provide proof. Now trust. So you create a trust. Again, you need the services of an advocate. I will not go into the details of registering a trust, but when you create a trust, you name the beneficiaries. So the children that you have, or whoever you want to inherit your property, you make them the beneficiaries of this trust. And when you create a trust, all the property that you have and you want your dependents to inherit, you put them under the trust management. Now, when you pass away, this property, all the property that you had put under the trust will not go through succession. There will be an automatic transfer and it cannot be challenged. And this is what some families have also done, where either there's a polygamy or you believe there will be a lot of wrangles. You see, once you put it in trust, you automatically elect whom you want to inherit. Therefore, nobody will challenge. The people named as beneficiaries under the trust are the only ones who are able to do what? Who are able to inherit. And it's automatic. All they need to do is provide a death certificate of the person who created the trust and who the titles to the property belong to. And the registrar will require them to also provide proof, like probably their ID and birth certificates, that they're the ones named in the trust, and automatic transfer will be done. So anything that is put under a trust is not subject to probate in court. Now that's that. Another way of managing your property if you have older children, is to do transfer of property inter vivos, meaning during your lifetime. But get to know when you transfer property during your lifetime, there's no reversal. So you have children, they are adults, and you want to bequeath each one of them. So what do? You get transfer documents and you transfer to them. That's it during your lifetime. If one of them mismanages the property, it will be too bad. That will be the end of it. We've seen examples in Kenya without mentioning names. If they manage it better, still good for them because it's their property. Now, another method that I see a lot of couples do is joint ownership. Now, joint ownership, if you do, you need to be very, very careful, because if you are married and you have property jointly with your husband or with your wife, when one of you dies, if one of you precedes the other, the one who is left, this property also does not need to go through succession. The surviving partner, all they need to do is get a copy of the death certificate of the deceased partner, and of course their ID, and they go to Registrar of Lands, and the property is transferred to them. It's known as transmission. So where property is registered joint, it does not form part of an estate of the deceased person. It doesn't form part of the estate of the deceased person. The surviving partner gets it 100%. So example, I'm married, my husband has 3 wives, and I've registered a property with him. If he passes away, this property is transmitted to him wholly. It doesn't form part of my estate. So ladies, if you're in a polygamous marriage, you need to consider, do I register property jointly with my husband, or do I put it under a trust? And death is uncertain. Of course, men die much faster than women in marriages, but still, you can't be certain who will precede the other in death. So ladies, you need to consider, when you're registering property, do I register it under a trust and I make my children the beneficiary, or do I register it as a joint property? Where should I precede my husband in death? It will form part of his estate, and once it forms part of his estate, if he had other wives or he marries, there's a possibility of my children sharing this property with the others. If again, now after my death, my husband remarries, and then he precedes this other woman in death, you see, whatever property there is will form part of his estate. Do I want another family, another woman and her children to come in and share what I had worked for during my lifetime with my husband? So to the married women who have property jointly, that is well and good, but you also need to consider this other unknown vehicle that is not commonly used in Kenya, known as trust. I would encourage you to strongly consider registering a trust, putting your property under the trust, and naming your children as beneficiary, as opposed to joint ownership. Or if it's property that you have solely acquired, you just register it under your name alone, so that when you die, it forms part of your estate. So ladies, you need to take key of that. Now, with that, Jennifer, I can see we have how many minutes left? Jennifer? 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 I seem to have lost Jennifer, but I'd like to ask if anyone is online and they have a question that they would like to ask.
Sorry, I'm here. So we have I had muted. We have we have 15 minutes. So, but for me, I'll ask a question. Okay. I'll ask questions so we have wills, we have trust, right? So
yes.
So, and most of the time when I hear the word trust is when I want to start an organization and stuff like that. That's a kind of trust that people, what is the difference between that trust, the trust when I am establishing an organization, and the trust that you're talking about?
The trust when you are starting an organization, that is like a foundation. Huh? It is different from this one. Now, the trust I'm talking about is where you are transferring property and including beneficiaries. The only activity under this trust is to own property for certain beneficiaries. Now, the other trust for organization, that is like an NGO. I don't know if the difference is coming out clear. Well, sorry, this is a question I wasn't so prepared for. So I'm afraid I won't do justice to it currently, right now, yeah.
Okay, probably for next week. And then again, right now, probably there's someone who's watching us and they have started thinking, oh, wow, okay. So where do I start? I need a will. You've told me I don't go download the templates online. And then where do I start? So the question is, where do I start? Because I want to start, I want to do a will. I have a few pieces of land, or I bought a few shares a while back, and I want to transfer, I want to, at least to create some form of inheritance process, something for my children. So where do I start? Because most of the people, yes, I want, but where do I start? Are you able, especially now, you know, yes, because you don't know how long this thing is going to go, you know, and the sad thing, I was reading about the story of that guy from Siaya. He was okay. In 5 days, he was dead, you know, and it's that quick. So how do I start this process?
Okay, if you want to do a will, all you need to do is get in touch with an advocate. I believe everyone in their circle know a lawyer or can get a friend to help them get a lawyer. And because of the social distancing, but you see, there's a very good tool like what we're using now. You can have a call with your advocate and you discuss and you tell him or her the properties you have, and they'll be able to draft for you the trust. And of course, sorry, not the trust, the will. And of course, when you are doing a will, you can only include properties that are in your name. So you will be sharing also with them the titles to the property. They will confirm it is yours. And they'll be able to draft for you a will and have it executed, yes. And oftentimes you have to leave a copy with the advocate who's drafted it. Yes, so a will is still possible now. And even after all this COVID-19 and the partial lockdown and social distancing is over, there's another estate management plan that we really make use of, and it's known as having a life insurance policy. I would encourage us to consider having a life insurance policy. Just get a financial consultant or an insurance agent, you sit down with them. They will be able to tell you which one is good for you, depending also on your age and your income, how much you're able to spare per month towards this insurance policy. Because if you have children or you have dependents, you are going to name them as the beneficiaries. Should you unfortunately die when your children are still in school, this policy will come in handy for them. Even if you don't pass away, but now if they will be going to university, and you look at the cost of university fee, if your policy shall have matured, that amount will be very, very good. Assuming you took a life assurance policy that at maturity gives you 20 million, and you take it now when your child is maybe 5 years old or they've just been born, by the time they're going to university, about 10, 15 years later, the policy shall have matured. And if you're still alive, that will be a very, very good amount for you to put towards the education. So we don't take a lot of insurances, but this is something also that I would like to encourage people to start considering. If you have family dependents, please take life insurance policy. Some time back, I saw an argument on Facebook where some lady was saying she doesn't see the need of taking life insurance policy because she has land. Now, to be realistic, between land and insurance policy, I don't know which one is easily converted into cash when you're not there. Because if you have land and the title is in your name, even if I want to sell it, First of all, I have to get a buyer. And even after I get a buyer, I have to do what? I have to do the probate so that transfer is done to them. But if I have a life insurance policy and unfortunately I pass away, the insurance is going to pay out within a very minimum period. So you have to consider, yes, it's good to have immovable property, but which one will be easier and faster to liquidate in terms of when you need quick cash? So those are the conversations people need to have. Yes.
Another thing I need you to touch is on issues to do with like guardianship. You know, right now, if something happens to me, who's
Yes.
going to take care of my children? You understand? Who is going to take care of my children? And some of us do not consider that, you know, and you find your children, you had good life, you had the money, you had the wealth, and it's still there, but your children are suffering. I want you, because that's something that I think is part of inheritance and stuff. What are the processes can someone take to be able to ensure that you have let someone to take care of your children, you know, beyond family, beyond kinship? What are the steps to make sure that my child, and I have left the proper documentation to ensure that if anything happens to me, I have someone who is going to take care of my children?
Now, there are two ways through which you can appoint guardians for your children. You can either appoint guardians for your children through a court order or under a will. If your children's birth certificate name both father and mother, then you cannot appoint a guardian through a court order if both of you are still alive. So you can only have guardianship appointed through a court order if one of the parents is deceased or if the birth certificate only names one parent. The other one is appointing a guardian through a will. So a will have many clauses, yeah? First is how you'd want your property to be distributed, how you'd want to be interred, and where, and if you're a person of faith, under what religious faith or organization or denomination, and if you have children, whom would you want to take care of your children? And when you appoint a guardian for your children, you need to talk to them first that I'm doing a will, but should I pass away, or should, if you are married, should both of you pass away, you need to talk to this person. Would you be willing to take care of our children? Once they give you their consent, it makes it very, very easy. You include them. And then do not appoint a guardian for your children, then bequeath someone else with the property. When you appoint a guardian for your children, it also follows that you should leave them means for looking after your children. Whatever you have, you don't have to be a millionaire, whatever you have. It could be, oh, I have that car. So let the car, if by the time I'm dying, that car is still there or any other property, let it be disposed, the money managed, and it goes towards maintenance of my children who will be under so and so guardianship. So yes, you can appoint a guardian through a court order or under a will. Again, this is why an advocate is necessary, because the advocate knows that where both parents are still existing, you cannot go to court to appoint a guardian, but you can do so under a will. And what are the requirements? What are the rules of writing a will? So it's very, very important. And when you're appointing a guardian for your children, remember also that it doesn't have to be your next of kin, because sometimes we know our siblings better, and we know that we have friends whom we've connected with better, who are in a better position to look after our children. So it's not necessary that you have your sister or your brother or your sister-in-law appointed as guardian. You can appoint anybody as guardian, but please let them know, talk with them, they agree, and of course, leave them property to look after your children. Yes, Jennifer.
Thank you so much, Enrica. So please, because we've been getting comments from our Facebook, and so how can someone get in touch with you if they would want to get in touch? Because it's yes, they are lawyers, but they are good lawyers, and you are one of the good lawyers.
Thank you.
all my friends, please don't kill me. And I'm going to get lots of texts like, why did you say you're not good? Anyway, because I've known Enrica for a while. So for me, I think one of the things is, if someone would want to get in touch with you to...
I'll share my email address.
Yes.
Okay, duloea@gmail.com. That is D for dog, U for unga, L for love, O for orange, E for egg, A for apple. duloea@gmail.com. That's my email address. Yes, I wouldn't share my phone number now unless someone gets in touch personally, is when I would share my phone number, but not now. I have to protect my privacy.
Thank you so much, Enrica. So next week again, join us. Please send us your questions. As you can see, Enrica is available. This video is available on YouTube, so you're going to continue watching it on YouTube, but also we'll try to put it on Facebook. So probably some of you, like last week's video, was on Facebook and on YouTube. So if you have any question, Enrica is on YouTube and is on Facebook also. If you have any question, you can tag her for a question on YouTube. And she was going to respond to your questions. Thank you so much, Enrica. We really appreciate for this, and see you next week.
Thank you, Jennifer.
As we discuss another topic on how to access justice system during this season. Thank you so much. Bye.
Thank you. Bye. Enjoy your day.
Thank you.